Ladies and gentlemen, we have officially lost the plot. OMG. But first, happy Wednesday. Happy hump day. It is midweek and there is just a lot going on, isn't there? How are you feeling? How's your day? Welcome back to this channel. We are going right in and we are going into It Ends With Never. So if you're ready, I'm ready. You already know what to do. Grab your emotional support lip gloss because what in the world is happening? You are in frame with Mandy Magnan. Okay, first. Big news. Congratulations, Taylor Swift, who announced her engagement via Instagram yesterday. And Blake Lively goes low, but Taylor Swift goes lower. This was obviously some kind of coordinated. I mean, you cannot even sway me to not know that this was some kind of coordinated announcement. She was saying a lot without saying a lot. You feel me? You're gonna tell me besties, godmother to your children, all of it? She announces her engagement. Taylor Swift announces her engagement on August 26th. August 26th. The day after your birthday. Couldn't have waited a week. I mean, Blake is lucky that she didn't do it on her birthday, but like the day after. Holy moly, I was laughing, and I'm so sorry. I know it's not nice, but I mean, you called her your dragon, and you used her a lot, and I don't think Taylor Swift is as innocent as a lot of people think that she is also in this whole effort. However, come on, I mean, the timing. And now you have Travis Kelce's dad, who has come out and said that he was asking his son, hey, when are you going to announce the engagement? And Travis said, when Taylor wants to. So this was all planned and plotted by Taylor. And honestly, sometimes it just feels good to be a little bitter and, get a little quick clap back in there. And this was... wow, my gosh, this was a big one. The day after, Blake Lively's still posting all of her stories about her birthday and all these people saying happy birthday to her. Most of the people are staff, but okay. Then Taylor just announces her engagement. Okay. That's enough. Let's get serious. Oh my gosh, I just was like, dang, that is brutal. That's something. But there's more, okay, because when I say we are losing the plot, people, the last few things that have been filed by Blake Lively, oh my gosh, and now we have a sneak peek into some of her deposition a little bit more, to where, yes, Blake Lively has said during her deposition that it was terrifying. She was scared for her life after the remarks that were made about her from Steve Soritz and some of the other Wayfarer defendants. Really? Then why are we just working on garden variety distress then? You were terrified? They were terrifying remarks. Oh my gosh. Oh, but we're going to go in. We're going to go in hard because Blake Lively's counsel has now come back yet again for BRYAN FREEDMAN, and they are coming for this man. And we're going to go over it because I clocked some stuff in there that I was like, y'all are just so crazy. Because why is it okay for you, Blake Lively, your spokespeople, your PR person, Ryan Reynolds, unknown sources, spokespeople, and your lawyers to be going to the media, as well as you started this with the media in the New York Times. You started it. You had it in the New York Times. That's crazy stuff. That's crazy. But Bryan Freedman going out and speaking on the behalf of his clients is harassment, bullying, traumatizing, It's a smear campaign. It's a smear campaign. Well, I would say that all of your sources, all of your spokespeople, that's an untraceable smear campaign because you can't put any names to the people doing it. And guess what? Why is it Bryan Freedman and Wayfarer Counsel going out and talking to the media? Because you have taken away their voice. You have taken away the voice of Justin Baldoni, Jamie Heath, Steve Saritz, Melissa Nathan, and Jen Abel. You have stripped them to be able to speak about anything because you've sued all of the Wayfarer PR. You've sued their crisis manager. You've subpoenaed all of the staff for TAG, JonesWorks, Wayfarer. You've subpoenaed over 107 content creators that even spoke about the whole ordeal. You are stripping them of their right of speech. You are stripping content creators of their freedom of expression and right of speech. And you wonder why it's Bryan Freedman going out and speaking on their behalf and not their spokespeople? They don't have any more spokespeople. You've taken that all away. You've taken it away. You've subpoenaed every single Wayfarer employee, TAG employee, Jed Wallace. I mean, all of the content creators, their own PR people, their own crisis manager. And now you're like, oh, well, it's because Bryan Freedman's the lawyer and he said it as a lawyer. Who else is supposed to speak to them? Because Wayfarer can't speak for themselves. Can you imagine if Justin or Jamie came out and made a statement? Ugh. I'm so sick of them. Blake Lively and her counsel. It's absolutely bonkers. And I want to say real quick before we dive into the court filings, why is it okay for Blake and Leslie Sloane and Ryan Reynolds all throughout August and to the present, spinning stories, talking to the media? I mean, we now know that James Vistuska said that Leslie Sloane was smearing Justin and Wayfarer all of August, and there's proof. But Bryan Freedman coming out and making a couple of statements here or there, you gave the New York Times the CRD complaint and thousands of text messages that you obtained illegally, by the way, or at least unmorally, at least in the shadiest way possible, with a fake lawsuit with an inactive company that your husband owns, Van Zandt. Let's keep saying it out loud. It's okay for you to go in the New York Times and call them sexual predators, to be able to say that they repeatedly sexually harassed you, to completely smear them in the New York Times, and then that they started a retaliatory campaign against you with zero evidence, even up to this date. But Bryan Freedman going and defending his clients, you have severely lost the plot. Why are you not trying to prove the sexual harassment claims? Why are you not trying to prove, the breach of contract? Why are you not trying to prove all of the other stuff? Why are you not trying to prove the actual reason why we're here? You care so much about your reputation, and that tells me that you weren't as violated as you're trying to make people think you were, because if you've been violated and your rights stripped away and your power taken from you, you wouldn't care about your reputation. You wouldn't care. But that's what you care the most about. And we wouldn't be here today had Betty Booze, had your hair care line, had all of your little businesses, yours and your husband's reputations succeeded. It ends with us. If your marketing efforts through Maximum Effort, your husband Ryan Reynolds business, if that marketing campaign would have, I don't know how you thought it was going to succeed, but by the stretch of an imagination here, if it had succeeded, and you won over all the survivors and victims with blow drying people's hair and giving them some alcoholic cocktails, wearing your florals. If that disgusting marketing campaign would have worked and your reputation would have succeeded, we wouldn't be here today. Which tells me all of the other stuff, the important stuff, the sexual harassment, every day repeated in your own words. Nah, no girl, You can't turn one over on women who have been through similar and worse. You can't. Because you're caring all about the wrong stuff. It doesn't make sense. And because the tables have turned against you, the tide is not in your favor. The average content creator following this case is not on your side. Now you want to cry further harassment. Oh, now Bryan Freedman's harassing me. Da, 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 da. However, if the tables were the other way and people were favoring you more, you'd have nothing to say about everything that Bryan Freedman's saying. It's just because people don't like you. They don't believe you. You haven't showed any evidence. You still have no evidence. You're attacking anybody that has anything to say about it. Keep digging. Keep digging. Because I don't even know how you can see out of the hole you're in right now. And your lawyers, they're just here for the dollars. They are just here for the dollars. And your husband's an op. I don't care. I will go on. I will go forever on this. You need to get people who are going to be in your corner, because right now, the mess, it's just absolutely, what are we doing? Do you not have anyone in your life giving you good advice, letting you know that this is absolutely bonkers? Freedom of speech. Speaking of, Perez Hilton tomorrow has his court date in Nevada. Popcorn Planet just submitted their motion to get quashed. It's just bonkers what you're doing. It's crazy. And now all these new filings. Okay, we're going to get into it. Because allegedly it's okay for Blake Lively's counsel to call them sexual predators, harassers, abusers, use Darvo, paint them out as being these predators, right? These horrible, horrible men who violate women. And not only Blake Lively, other women on set. It's like a repeated pattern. That's okay. But for Bryan Freedman to make a gag about Madison Square Garden and having her deposition, it's not. Okay, what are we caring about here? What is going on? It's very weird. So we're going to go over that with examples that Lively put in herself, her counsel. And it doesn't look good. Okay? They've also come back on Leslie Sloane. And also we have Jed Wallace. And you know his lawyer is just no nonsense. No BS. This is what it is. You're not okay. Okay? You're not okay. But anyway, let's go through all of that. And then we'll have a little chat at the end. First, let's go into everything with James Vistuska, because it's kind of like the fastest one. So it was kind of nice to be questioned and to take deeper looks at James Vistuska and to see, what side he's on and if he's working for Wayfarer. But I think we had it right the first time. But I love looking at both sides of the coin and trying to, see what else is going on here. And I'm really shocked that Wayfarer, first of all, are not absolutely annihilating Blake Lively and her counsel and all of the parties at this point, because what complete nonsense. And I know that they have enough proof, and I know that they can really hammer it home if they wanted to. And I think Blake Lively should count her lucky stars. Is that a saying? Count your lucky stars? Count your blessings that she is dealing with Wayfarer and not people that would actively seek to destroy her and actively seek to attack her and actively seek revenge in the highest form to completely annihilate her and her husband for what they've done here. All they want to do, it seems like, is defend themselves and clear their names. And thank the heavens for Blake Lively. She should be thanking, because her, Leslie Sloane, Ryan Reynolds, all of them, ugh, God, gross. If it was anybody else, I swear, that had malicious intent or wanted to really, like, they could. I know they could already, right? But this is in response to Leslie Sloane, who just came real quick. She came real quick after James Vituska filed his letter being like, hello, remember me? Yes, remember me? Please, give me my attorney fees. This is the letter, and this is coming from Elaine S. Garofalo. She writes, we respectfully submit this letter in response to Leslie Sloane and Vision PR Inc.'s, collectively Sloan, SIR reply filed without leave of court in support of her motion in attorney fees and cost. So she filed, but you're not allowed. The judge already made a ruling that once one letter is filed, then you can write a letter in opposition, and that's where it stops. That's it. So she had already filed this motion for attorney fees a while back, but I guess she just wanted to, show that she has James and look at me, please don't forget, give me my money. It's strange, but as leave of court was not obtained prior to filing a SIR reply, it should not be considered by the court in deciding Sloane's motion for attorney fees. Striking a supplemental filing where the plaintiff neither sought nor received permission from the court to file a SIR reply, even if leave had been requested, the SIR reply must be disregarded for the reasons set forth below. Well, tell us, Elaine, let's go. First, Sloane disingenuously suggests that this is the first time she has asked the court to consider the text contained in Exhibit A. That was James's text between him, Melissa Nathan, and Bryan Freedman. To the August 21st, 2025 declaration of James Vituska, a former Daily Mail reporter. But Sloane had already cited, relied on, and discussed this exact text message in her first reply brief in support of her motion for attorney fees. And they come with receipts. Docket 420, y'all. Docket 420, page 7, paragraph 190. Okay. Wayfarer party's complaint filed in the LA Superior Court, which included an image of this text. Sloane's SIR reply is thus improper. Second, the text message is not conclusive evidence. The text purports to comment on a screenshot of another text message between Vituska and Sloane, which is not included with Exhibit A. Referring to the screenshot of a text between Sloane and Vituska, Vituska says that in that exchange, Sloane does not say anything about sexual assault. That does not demonstrate that Vituska never said that Sloane told him Lively was sexually assaulted or harassed. Okay. So what they're saying is, like he said, in that they're talking, James was talking about previous text messages, and in those text messages, it doesn't say that. But they're saying he was talking about another conversation they had. That does not demonstrate that Vituska never said that Sloane told him Lively was sexually assaulted or harassed, nor are the Vituska declarations reliable. The two declarations are inconsistent with one another and appear to be intentionally inconsistent as well. Further, Vituska's credibility is suspect. He's sus. He's so sus. He's so sus, guys. Like, flipping and turning and flipping and turning and flipping and turning. His credibility is suspect, as he was fired from the Daily Mail because he shared the text message quoted in the Wayfarer party's complaint and insinuated himself into the story rather than just report on the story. His efforts to distance himself from the text is not surprising. In any event, Sloane can only speculate that the text quoted in the Wayfarer party's complaint is the sole support that Sloane told Vituska that Lively was sexually assaulted. The recycled text in Exhibit A is thus not the smoking gun Sloane pretends it is. Vituska's inconsistent and ambiguous statements, which have not been subject to cross-examination, cannot establish that the Wayfarer party's claims are wholly without a substantial basis in law or fact, or filed in bad faith. Finally, even if Sloan could successfully disprove that a text quoted in a single sentence in the Wayfarer party's complaint was later recanted by Vituska, she cannot. That would not mean Sloan's motion for fees should be granted. To begin with, Sloan's motion was procedurally improper. As the Wayfarer parties pointed out in their opposition, a motion after a Rule 12b-6 dismissal is not the proper procedure to seek fees under New York civil rights law. On its face, 70A applies only to an action claim, cross-claim, or counterclaim. The overwhelming majority of courts in this district interpret the language in this statute to require parties seeking anti-SLAPP damages to bring an affirmative claim for relief under 70A, not proceed by a motion after dismissal. So they're saying the judge can't grant this to you. You have to sue us. You have to bring a claim to us. You're dismissed. You're out of here. Get out of here. Second Circuit and the majority of district courts within it hold that the state anti-SLAPP motions do not apply in federal actions. The rationale for this rule is that the anti-SLAPP statutes conflict with federal rules of civil procedure 12, 56, and 11 as they address the same questions. The Second Circuit has held that California's anti-SLAPP statute does not apply to federal courts sitting in diversity. Although the Second Circuit has not spoken on whether New York's anti-SLAPP provision applies in federal courts, most cases in this district hold to the contrary. Further, assuming Sloan were able to overcome these procedural infirmities, she cannot. To be entitled to attorney fees, Sloan must prove the Wayfarer party's claims against her were wholly without a substantial basis in fact and law, and that all claims alleged against her were made in bad faith pursuant to the court's inherent powers. The Wayfarer party's defamation claim against Sloan included far more than what Vituska said in the one text message referred in the complaint. The Wayfarer parties alleged Lively, Sloan, and Reynolds worked together to spread a false narrative about them to the New York Times to the effect that they engaged in inappropriate conduct towards Lively and retaliated against her for reporting the misconduct by engaging in a campaign to ruining her reputation, and also alleged that Sloan individually made false statements to other press outlets that Baldoni had committed sexual misconduct. Ew, I just got an audition. Yay! It just popped up on my phone. Anyway, we're back to it. So yeah, it was way more, guys, than just, the thing that Vituska said. I mean, what are they going at here? But I wish they would have put they could have put so many details, I think they're just playing it a little bit too nice, too safe. I would have dropped all the info, drop every single thing, but I get it. They're only replying to Sloan, but and also alleged that Sloan individually made false statements to other press outlets that Baldoni had committed sexual misconduct. The allegations included that Sloan and others concocted a plan whereby Stephanie Jones would seize Abel's phone upon her departure and mine it for messages that, stripped of context, could be used to concoct a false narrative that the disastrous press coverage of Lively callouts and opportunistic comments and the public reaction to those comments were not Lively's fault, but the result of a calculated, though in reality non-existent, smear campaign by Baldoni and his team. In sum, Sloan's surreply, which merely rehashes an argument about a text message she already made in her reply brief, does not alter the conclusion that Sloan's motion for attorney fees must be denied. I just can't believe that people are willing to start something like Leslie Sloane and Ryan Reynolds and Blake Lively clearly did. They clearly started this. I mean, Blake Lively, all you have to do is say Van Zandt and New York Times. What? That's crazy to me. And now you want to, what? Because they got a little kickback on you. They got their little lick back and tried to sue you, which was, in my opinion, wrongfully dismissed. You want to now be begging for your attorney fees? Get out of here. Just like this BS we're about to read right now, which is a reply in further support of Blake Lively's motions for sanctions against defendant's counsel. They already filed. Freedman answered. And now they're filing another one in further support. It's not welcome here. Like, what? They're literally breaking the rules anyway. We continue because this is absolutely bonkers what we're going to read. I think it is so nuts. And this is where we are losing the plot. You're so worried about Bryan Freedman's comments. It doesn't make any sense to me. Like, what are you doing? Like, what are we clocking? Like, I don't get it. But anyway, this is it. This is the big fish that they're after here, Bryan Freedman. The opposition filed by Bryan Freedman and the Wayfarer defendants does not seriously challenge that Mr. Freedman's repeated extrajudicial statements have targeted Ms. Lively's character, credibility, and reputation. As such, those statements presumptively violate New York Rule 3.6 and are sanctionable under this court's February 3rd order. Leaving aside the opposition's repeated ad hominem attacks, Mr. Freedman's primary response is that his press campaign is not necessarily prejudice the jury pool against Ms. Lively, but the consistency and volume of Mr. Freedman's themes challenging Ms. Lively's character and credibility have created a situation in which the issue is not whether jurors will remember Mr. Freedman's statements, but whether they can escape them. What about the New York Times? Like, that has an even further reach and is a much more serious publication than giving a statement to Popcorn Planet. No offense, it's the, you know what I mean? Or being on the Megyn Kelly show. Lively's counsel was on CNN. Like, they gave the story to the New York Times. Like, I mean, it's just so bonkers. And you can't prove that. Like, what a story. Oh, it's not whether or not they'll be able to remember what he said, but will they be able to escape them? The opposition's attempt to blame Mr. Freedman's misconduct on various press statements made on Ms. Lively's behalf, like his disingenuous rebranding of his proposal to hold Ms. Lively's deposition at Madison Square Garden as a scheduling statement, fall flat. But it is, because she wasn't showing up. She rescheduled it multiple times. So if you watch the entire segment, he says, I want to see if she shows up. I'm going to ask her what her name is. Let's see if she shows up, which she didn't show up to. Like, I mean, it was rescheduled. So, I mean, he wasn't lying, you know? And anyway, so they're real mad about the Madison Square Garden thing. Real mad, still real mad about it. If, in sum, Mr. Freedman has plainly violated Rule 3.6, he has identified no cognizable, justification for his violations, and accordingly, Ms. Lively respectfully requests that her motions be granted in its entirety. Mr. Freedman violated Rule 3.6 in the court's order. In her opening brief, Ms. Lively established that Mr. Freedman has repeatedly and viciously attacked Ms. Lively's credibility, character, and reputation in violation of the rule. He hasn't spoken to the media, I think it was the beginning of June, maybe even earlier. I mean, we could check again. I've said it in so many videos, but it's been a long time. And I think they only have like 6 to 10 statements that he made. Meanwhile, Lively's spokespeople are talking to the media every single day. Damn near. You know. Mr. Freedman does not deny and therefore concedes that he has made each of the statements identified by Ms. Lively and that those statements targeted Ms. Lively's credibility, character, and reputation. These statements reflect Mr. Freedman's efforts to publicly paint Ms. Lively as 1, a liar who is afraid of the truth and so lacking in credibility that she will look at a scene and say, the sky is not blue. 2, arrogant, a bully, and a privileged elite. 3, deserving of the organic backlash against her self-concocted disaster, not the Wayfarer smear campaign documented in Discovery. And 4, not credible, giving her husband's SNL appearance. First of all, there's nothing documented in discovery that proves a smear campaign yet. That's the whole thing. Nothing. It was organic. And yes, everyone thought your husband giving a joke at SNL 50 was horrendous. What husband laughs and mocks his wife's trauma? He did it all through Deadpool and Wolverine. So it was okay to laugh about it then. It's okay for your husband to laugh about it. But Bryan Freedman, he's supposed to take you real seriously. Real serious. Come on. If the statement relates to the character, credibility, reputation, or criminal record of a party, or the expected testimony of a party or witness, that's what counts if you break the rules. Now let's just remember character, credibility, and reputation when we get into the statements that they made about Wayfarer that they're saying, nah, it's not that bad. It's not that bad. It's not as bad as Bryan Freedman. Then they go into what the professional ethics are, and they say that holds true here. A sustained public relations campaign attacking the character and credibility of a sexual harassment plaintiff creates an unacceptable risk of tainting the jury pool, particularly given Mr. Freedman's admission that in these kinds of cases, once someone says something, it becomes fact. Presumption aside, under any analysis, Mr. Freedman's statements attacking Miss Lively's character, credibility, and reputation have a substantial likelihood of prejudicing Miss Lively at trial. For months, Mr. Freedman has sowed into the minds of the potential jury pool that Miss Lively is a privileged elite. I mean, isn't she though? Who looks at Ryan Reynolds and Blake Lively and doesn't consider them privileged Hollywood elites? Isn't that what she has based her entire life and reputation on? What? Not privileged elites don't get invited to Met Galas. Non-privileged elites don't fly on private jets and you get paid $3 million to do a role in a movie where everyone else is getting paid pennies compared to that. You are a privileged elite your entire life. You started because your dad got you roles because he was in Hollywood. You are the Nepo of Nepo babies. That is not a lie. You are a privileged elite. You can't escape that whether Bryan Freedman says it or not. What? Anyway, so he tainted the jury pool because he claims that Miss Lively is a privileged elite intentionally twisting and curating the law to weasel her way out of a self-concocted disaster that she couldn't handle, perhaps because of a narcissistic quality. Couldn't have said it better myself. Such comments clearly prejudiced the due administration of justice and potentially interfere with a fair trial by publicly tarnishing the credibility of Miss Lively. This is not a matter of involving a single isolated or discrete statement. Rather, Mr. Freedman has made repeated statements across months, which are then repeatedly recirculated by outlets reaching millions of audience members in a litigation that has been dominating headlines and drawing attention at every step. This belies his effort to downplay the significance and prejudice of his statements, especially in light of his ongoing media efforts, which include not just a website that he and his team established, but also sustained engagement with tabloid and social media platforms whose conduct he praises and expressly encourages. Simply put, the issue is not whether jurors will remember Mr. Freedman's statements, but whether they can escape them. I bet Ryan Reynolds must have come up with that line or something because they are just so proud of it. There, after a mistrial, the plaintiff's attorneys made several comments to reporters, most of which were made on a single day, including that. So now they're going to the case that, Bryan Freedman quoted, including that were one juror shy from winning the case and were fired up for the next trial. The defendant sought sanctions under Rule 3.6 of Michigan's Rules of Professional Conduct. In denying the motion, the court found it nonsensical that the statements, which are akin to a reporting of the litigation, could possibly manipulate or influence the jury. At best, the statements at issues amounted to puffery about the likelihood of success in a subsequent trial and had nothing to do with the character or credibility of the parties. The other case cited by Mr. Freedman are equally in opposite. Anyway, then they're trying to rebuke his law cases that he put in But the footnotes I thought were particularly jokes. It says number 2, first of all, it was Freeman who, on a podcast appearance with his former client, Billy Bush, argued that these TikTokers and people on YouTube, they're amazing. They're brilliant. Those types of people that have that type of information, that are willing to do the type of diligence, should actually be the jury one day. Not lying. It could be. I mean, if you're a New York citizen, then it says it has since been revealed through discovery that the Wayfarer parties are colluding with several content creators, including Perez Hilton, Candace Owen, and Andy Signor of Popcorn Planet, to perpetrate some of the most hateful and anti-lively rhetoric. That is a bold-faced lie. That's a lie. It hasn't been revealed through discovery that they've been working and colluding together. They gave them maybe a statement. I mean, Popcorn Planet has come out on record and said, yeah, we reached out for a statement from Lively and from Freeman. Like, Lively's counsel didn't give us anything. It's crazy that they can literally lie and say that through discovery, it proves that they've been colluding with several content creators. I mean, it hasn't been proven. It's so crazy. News outlets regularly utilize, and it's funny that they're saying that they're colluding with, let me just go back to this because I have an arrow for a reason. This really peed me off yesterday, because in that same exhibit that they're showing the answers of the interrogatories, what about all the other journalists? What about all the other media outlets? It named like TMZ, CNN, People, da-da-da-da-da-da-da-da-da. Then it said Popcorn Planet, Perez Hilton, Candace Owens. But how come you're not in here saying that they colluded with all those other people? Page 6, the Daily Post, the Daily Mail. Oh no, just these content creators? Oh my God, make me vomit. News outlets regularly utilize social media platforms to connect to a wider audience, both within and outside the traditional geographic broadcast television limits. People magazine, where a number of Mr. Freeman's statements were published, alone has an estimated readership of over 98 million across all platforms. He didn't tell them to write that. Go after people then. Like, he can't control what people are going to report on. He can't go off that. Every time Blake Lively files something crazy in the media, or says something nuts in this court, or does something wild in this court, it's blasted everywhere too. Who's purporting this story? Who's furthering this narrative? Lively's counsel. This is all for PR. It's so crazy. The video of Mr. Freeman's full-length interview with Megyn Kelly on June 11th has over 352,000 views. 352,000? Not even a milli? I thought that video would have blown up and done millions. That's wild. Anyway, Mr. Freeman also does not meaningfully explain how the fast-approaching March 2026 trial is far enough in the future to warrant its no harm, no foul approach. Even if the mere 7 months to trial were sufficiently attenuated in an ordinary case, it is not. Cases that are widely publicized or sensational are those that are most likely to be recognized by courts as prejudicial. Oh my God, my nose is so itchy. Sorry, guys. As prejudicial to a jury. Oh my God. The reality of modern media and the internet, however, means that the potential exposure. Mr. Freeman's only remaining argument as to prejudice is that it is nonsensical that an impartial jury cannot be seated, but that proves too much. If that argument were sufficient, there would be no need for Rule 3.6, and Mr. Freeman would never have stipulated to that application of Rule 3.6 as a rule for this case. Instead, as the United States Supreme Court has noted, even if a fair trial can ultimately be ensured through voir dire, change of venue, or some other device, these measures entail serious cost to the system, and the state has a substantial interest in preventing lawyers from imposing such costs. So what you're saying, that because Bryan Freeman talked to the people, made statements that you could, ask for serious measures to be taken and change of venue and but you're not. While Mr. Freedman is correct that attorneys are not prohibited from speaking to the press, particularly in high-profile cases, such interactions with the press must be conducted within the confines of an attorney's professional ethical obligation, as is necessary to mitigate the recent adverse publicity. Likewise, statements about the claim, offense, or defense, information contained in a public record, and the scheduling or result of any step in the litigation are permissible when made without elaboration. Mr. Freedman attempts but fails to distract from his own violative statements by blaming Miss Lively's counsel or others who speak on Miss Lively's behalf, and summarily concluding that if Mr. Freedman's statements are sanctionable, so are those of Lively's counsel. Even a cursory glance at the statements raised by Mr. Freedman reveals the difference between his statements that violate Rule 3.6 and those on behalf of Lively which do not. First, Mr. Freedman identifies numerous statements made by a non-lawyer spokesperson for Miss Lively and basically asserts without any evidence or authority that these were in fact statements made by lawyers, euphemistically called spokespersons. I think they are too. I think it's either Leslie Sloane, Ryan Reynolds, or her lawyers. Y'all are some shady people. Look what else you've done in this case. Let's go back to Van Zandt. How did we get these text messages? Right? So okay. Okay. Oh my gosh. This is where they try to get him by saying that because he's a lawyer and, the people talking on behalf of Miss Lively aren't lawyers. Okay. Mr. Freedman ignores the straightforward principle that New York Rule 3.6 governs the conduct of lawyers, not clients, or their public relations advisors. That is why Miss Lively has not moved for relief under 3.6 for any of the countless derogatory public statements made by the Wayfarer defendants, their public relations professionals, or the content creators with whom the Wayfarer defendants have immediately coordinated. They're not coordinating with content creators. They don't have PR professionals saying anything because you have sued them or subpoenaed them. Do you understand this? The only people that can speak for Wayfarer right now are the actual lawyers. I don't understand why this is so hard to understand. But I did make a note here. Let's see what this note says. When I was reading it, I was not happy when I was reading this last night, guys. Let's see what this note says. Oh, it's the exact same thing I just said. Guess who is speaking for Wayfarer, for Justin, for Jamie? They're lawyers because you are suing all of their PR, all their people, or have them subpoenaed all of the staff from Jenny Full, Wayfarer, and Melissa Nathan. Yeah, I agree with me. But yeah, what do you, this is so crazy to even say, even just this sentence alone where she was like, well, they haven't moved for relief for all of the things, all of the public relations professionals or the content creators. What else are you trying to get? What else are you trying to get? Against freedom of speech, girl. Okay? The distinction is not theoretical. As the United States Supreme Court has explained, it is because lawyers have special access to information through discovery and client communications. Their extrajudicial statements pose a threat to fairness of a pending proceeding since lawyer statements are likely to be received as especially authoritative. Mr. Freedman's attempt to justify his own misconduct by pointing to statements made by non-lawyers is futile. Second, none of the statements Mr. Freedman identifies violate New York Rule 3.6. Many of the statements do not even mention Mr. Baldoni or the Wayfarer defendants. Statements number 1, 4, 11, 12, 14, and 15, while the vast majority of remaining statements are presumptively permissible comments regarding the claims, offenses, and defenses in the action that refrain from attacking the credibility, character, or reputation of Mr. Baldoni and the Wayfarer defendants. Okay, we're going to talk about it. Then they say, in any event, many of the spokesperson statements were made in direct response to statements initiated by Mr. Freedman. Please, these statements do not assert that Mr. Baldoni will fail to show up for trial, give false testimony, or to bully others. Can we, why are you so tied on this whole Madison Square Garden deposition? She's not going to show up for deposition. You did show up. You did have your deposition. So that comment is over and done with because it actually happened. You proved them wrong. You sat there and got deposed. So why do you care so much about that one statement? Because the deposition happened. So what? It's kind of like null now, isn't it? Mr. Freedman has also not made any showing beyond his own conclusory statement as to how his over-the-line statements were justified by anything. Ms. Lively's counsel said in the press, Mr. Freedman's bald assertion that his statements were absolved by the prejudice created by the incessant press releases and interviews published by Ms. Lively and her counsel fails to demonstrate what publicity rendered any of his specific statements necessary, or that they were properly limited to such information as necessary to mitigate the recent adverse publicity. The statements that he defends as discussing scheduling are in fact statements to convince the public that Miss Lively will attempt to avoid her deposition because she is afraid of the truth. The same is true for Mr. Freedman's taunt that Miss Lively should sit for a public deposition at Madison Square Garden and that he would sell tickets or stream it, which might constitute appropriate scheduling for a boxing promoter, but is unacceptable for a licensed attorney discussing civil litigation. Similarly, the statements Mr. Freedman describes as concerning the amended complaint, specifically the documents do not lie, people do, and that Miss Lively is a Hollywood elite who does not need discovery to find out who smeared her, just the mirror will do. What's wrong with those? I don't see anything wrong with those statements. Documents do not lie. People do. Okay, so if you're not lying, you're not lying. Show the documents. Show the proof. Show the evidence. And she is a Hollywood elite. And we don't need discovery to find out who smeared her because everyone knows that it was her and her husband's own doing. I mean, it's pretty obvious, guys. Do not concern any claims or allegations in the amended complaint, but rather characterize Miss Lively as a liar and a person of bad character who invited press attacks, absolving, of course, the Wayfarer defendants of their smear campaign against her. He's not here to throw his clients under the bus. He's here to defend them. And also, you started it. You went to the press first. You went to the New York Times. You started in the press. You started litigating this in the press by giving them the CRG complaint. This is insane. And there's metadata to show that you had been colluding with them for months before that article even dropped. I'm over it. I'm over these lies and like the whole smear campaign and Mr. Freedman, and it's like absolutely insane, okay? Oh gosh, it's just so annoying at this point. Mr. Freedman's argument that his statement number 5 is permissible as a matter of public record that Miss Lively faced media backlash ignores the source of this backlash is an issue in the currently pending litigation. Regardless, none of these statements are without elaboration as required by New York Rule 3.6. Mr. Freedman's failure to obey the court's clear and ambiguous pretrial order incorporating New York Rule 3.6 violates Federal Rule 16F and is sufficient grounds for the court to impose whichever sanctions it feels is appropriate under the circumstances. Miss Lively seeks only a public admonishment and an award of cost and fees. Oh, okay, that's it? If the court decides to impose sanctions, Mr. Freedman concedes that those are proper sanctions. Indeed, he makes no objection to these sanctions, instead entreating the court to reject the request to revoke Mr. Freedman's pro-hack vice admission, remarking that no punishment for a perceived slight would be too draconian for Miss Lively. It is telling that Mr. Freedman fixates on this purportedly draconian sanction because Miss Lively did not request that relief at this time and only reserved her right to seek it if Mr. Freedman continues to refuse to follow the rules of this court. So they're saying like, oh, well, we didn't ask for his, him not to litigate the case, but he wants to like throw that in there. All we said was we reserved the right, which is like a slight of threatening, isn't it? So like, why wouldn't he bring it up? Like, hey, you're not going to hold this over my head. Miss Lively reserves all rights to seek appropriate remedial instructions prior to trial, as well as to seek additional sanctions in the event Mr. Freedman continues to violate the rule including but not limited to revocation of Mr. Freeman's pro-hack vice admission. Finally, the court may also sanction Mr. Freeman under its inherent power to tandem with or in addition to any sanctions imposed by Rule 16F in light of Mr. Freeman's willful disobedience. In addition to the reasons set forth Ms. Lively's opening brief, Mr. Freeman's opposition further demonstrates his willful disobedience. Yeah, he's been a bad boy, Judge. He purported to welcome this court's entry of its Rule 3.6 order. He acknowledges that his statements regarding a party's credibility, character, or reputation ordinarily materially prejudicial to the proceedings, and yet he nevertheless admittingly engaged in that conduct a minimum of 10 times in half as many months. Mr. Freeman's actions and admissions illustrate his bad faith. Therefore, the court should impose sanctions under its inherent power. 20,000 sanctions for bad faith conduct. Now let's just quickly see what kind of statements her lawyers made that said that, oh no, this is totally okay. We never came after their credibility, character, or reputation. So here it says, because they're saying, oh, no mention of Mr. Baldoni or any Wayfarer defendant. Okay. It literally says this is not a feud arising from creative differences or he said, she said situation. Sexual harassment and retaliation are illegal in every workplace and in every industry. A classic tactic to distract from allegations of this type of misconduct is to blame the victim by suggesting that they invited the conduct, brought it to themselves, misunderstood the intentions, or even lied. Another classic tactic is to reverse the victim and offender and suggest that the offender is actually the victim. These concepts normalize and trivialize allegations of serious misconduct. Media statements are not a defense to Ms. Lively's legal claims. We will continue to prosecute her claims in federal court where the rule of law determines who prevails, not hyperbole and threats. Because they're saying because they didn't say Mr. Baldoni or the Wayfarer defendants, it's fine. Give me a break. Next, they said, this lawsuit from Justin Baldoni, Wayfarer Studios, and its associates is another chapter in the abuser playbook. So calling them an abuser, that's fine. This is an age-old story. A woman speaks up with concrete evidence. A woman speaks up with concrete evidence of sexual harassment and retaliation, and the abuser attempts to turn the tables on the victim. Again, calling them an abuser. This is what experts call Darvo, deny, attack, reverse, victim, offender. Further, Wayfarer has opted to use the resource of its billionaire co-founder, defendant Steve Soritz, to issue media statements, launch meritless lawsuits, and threaten litigation to overwhelm the public's ability to understand what they are doing is retaliation against sexual harassment allegations. They are trying to shift the narrative from Ms. Lively by falsely claiming that she seized creative control and alienated the cast from Mr. Baldoni. The evidence will show. He said this on January 16th. It's August 27th. There's still no evidence. I'm just putting that out there, guys. The evidence will show that the cast and others had their own negative experience with Mr. Baldoni and Wayfarer. The evidence will show that Sony asked Ms. Lively to oversee Sony's cut of the film, which they already selected for distribution and was a resounding success. Their response to sexual harassment allegations, she wanted it. It's her fault. What? Their justification for why this happened to her, look at what she was wearing. They've never said that. This is off. This is horrendous. In short, while the victim focuses on the abuse, the abuser focuses on the victim. The strategy of attacking the woman is desperate. It does not refute the evidence in Ms. Lively's complaint, and it will fail. Are they literally trying to play the oppression game and try to say that, like, I didn't know that I ever read that before. Their response to sexual harassment allegations, she wanted it. It's her fault. Their justification for why this happened to her, look what she was wearing. They're not trying to compare what Blake Lively, even in her CRD complaint, is to what I think they are they? Because that's gross. Anyway, they say that that's not an attack on credibility, character, or reputation. Okay. Next, they say to Deadline, Miss Lively's counsel says any woman who has been inappropriately touched in the workplace will recognize Miss Lively's discomfort. They will recognize her attempt at levity to try to deflect the unwanted touching. No woman should have to take defensive measures to avoid being touched by their employer without their consent. While they are focused on misleading media narratives, we are focused on the legal process. We are continuing our efforts to require Mr. Baldoni and his associates to answer in court under oath rather than through manufactured media stunts. So they're saying that was not an attack on credibility. It's a response to releasing video footage into the public, and it only discusses claims, offensive, or defenses. I mean, the fact that you guys talk about any woman, first of all, when this was happening, who was going through a toxic workplace harassment claim? Myself, me, and I still am on the side of Justin Baldoni, okay? So not every woman. And then they say non-lawyer statements. But guess what non-lawyer statements are? An untraceable smear campaign. Because you don't know who's saying them. It's absolutely insane. Here, they actually talk about Bryan Freedman. What is Bryan Freedman hiding? After promising to release all the receipts, Freedman ran into court to keep secret the phone records of who Baldoni, Heath, Soritz, Nathan, Wallace, and Abel were calling during their retaliatory campaign. Another spokesperson said, the New York Times correctly calls out Justin Baldoni's lawsuit for what it is, a shameless PR document that has no business in a court of law, Then they use Justin Baldoni's words against him about how you should believe all women. No, because you know what? All of the other statements, we've read them, we've seen them. Spokespeople, they're not the lawyers, they're not this, they're not that. But since y'all like to use Justin Baldoni's words against him, Blake, in all of your amended complaints, are you confident enough to listen to the women in your life, to hear their ideas and their solutions, to hold their anguish and actually believe them, even if what they're saying is against you? And will you actually stand up to something so that one day we don't have to live in a world where a woman has to risk everything and come forward to say the words, me too? Well, were you and your husband confident enough to listen to the women, all of the victims, all of the survivors, everyone that has ever experienced DV in August when they told you how absolutely disgusting the marketing campaign were? When they were telling you, what about DV? When they asked what can they do to reach out to you to tell you like their stories, and then you said, what do they want? My share location? And you mocked them and laughed at them? Were you and your husband brave enough to actually believe the women telling you that you're making a mockery and a joke about DV? Were you able to switch it and pivot? Were you confident enough to listen to the women, to hear their ideas, to listen to their stories, to tell you? And a lot of people were telling you. And still, a year later, over a year later, you are choosing to still ignore the women who had an issue with your marketing campaign because you were trying to shop your Betty Boo's alcohol line and your hair care products, and you were laughing and mocking and making a joke about something that women experience at a high rate every single day. You still to this day don't think that the women that had something to say about what you, your husband, and Maximum Effort did to the promotion of It Ends With Us was from our own voices, our own stories, our own past, our own experiences. You still think that it was some untraceable smear campaign, that we had to get paid and bribed and coerced and all of this stuff in order to talk about you, to talk about how disgusting you and your husband did. It was supposed to be a serious movie to create change, to end generational cycles of abuse from what our mamas, our aunties, our grandmas, our great-grandmas went through, and that we're still experiencing today. And over a year later, we're still here where you can actually stand with your full chest and say that our voices, our critiques, our honest opinions about the marketing that you guys did was bought, was paid for, was orchestrated by the Wayfarer defendants and not from our own experiences is disgusting. Okay, well, I just had to let my hair down there because things got a little bit serious. Anyway, that was my monologue for the day. Sorry about that, guys. Let's go into Jed Wallace. Okay, let's just go into a little Jed. Blake Lively is over here in the courts filing motions to compel, motions for documents, saying that Jed didn't give them everything, da-da-da-da-da, and she's filing motions to compel for everybody, for Wayfarer, for Jed, for everyone. So basically, Jed Wallace is just saying, yo, you are crazy. I have nothing. This is insane. I'm just summing up the 16 pages. I mean, he's basically saying, I don't got nothing. What do you want? But we'll just go over the introduction here and a couple of spots that I thought were quite to the point and humorous, if I may. Lively's motion to compel is long on rhetoric, short on substance. Faced with the inconvenient truth that the Wallace defendants played no role in any alleged smear campaign, Lively now seeks to create discovery that simply does not exist and never has, or to otherwise engage in a fishing expedition to flesh out an empty narrative. Lively demands answers to sweeping and irrelevant discovery requests, insists that ephemeral signal messages must be somewhere, and seeks post-complaint communications squarely protected by either attorney-client privilege or the work product doctrine. Lively's motion is not a bona fide effort to obtain necessary evidence. It is an attempt to rewrite the script because the controlling facts do not support her narrative. Having already missed her chance to take the deposition that could have addressed her concerns, Lively canceled the early July deposition of Street that was to be the first deposition in the case by agreement. Lively now turns to motion practice as a substitute for diligence. The proportionality mandates of Rule 26, the court's scheduling order, and basic notions of fairness all foreclose this tactic because the requested materials do not exist, are outside the permissible scope of discovery, or are protected by privilege. The motion should be denied in its entirety. Then they go on to say that the record establishes the Wallace defendants' limited involvement in the events underlying this litigation. Street's engagement was confined to monitoring social media and advising on public engagement, all remotely from Street and Wallace's rural Texas location. The Wallace defendants have now fully complied with their discovery obligations under the federal rules of civil procedure, producing all non-privileged and relevant documents in their possession, custody, or control long ago, with a small production going out this week based on the meet and conferred efforts to date. The limited numbers of documents produced by the Wallace defendants does not reflect deficient discovery efforts, but rather is consistent with their limited role, a point underscored by Lively's testimony that she cannot identify any publication attributable to Wallace or Street in the context of the so-called smear campaign. Lively served the Wallace defendants with several discovery requests on March 14th and June 4th, to which the Wallace defendants timely responded. Unsatisfied with the reality that the facts do not conform to her version of offense, Lively resorted to accusations of deficient documents, production, and discovery responses, including going so far as to complain of the Wallace defendants' failure to produce documents or provide information they simply do not possess and never have, or that does not exist and never has. During conferrals, Lively's counsel failed to raise issues now before the court or provide the Wallace defendants' counsel with meaningful time to consider proposed discovery modifications as Lively raced against this court's deadline and did so unsuccessfully, filing an untimely motion. Then they say that the court ordered July 15th, 2025 is when the motions to compel regarding all party document production in responses to requests currently outstanding shall be filed no later than August 1st, but Lively filed the motion on August 22nd, 3 weeks after the court imposed deadlines. After 4 months, 4 months after the Wallace defendants responded to Lively's first set of interrogatories, and over 1 month after the Wallace defendant responded to Lively's second set of interrogatories and requests for production. And they do go on to say that the interrogatories that they're seeking, she just like doesn't like the answers to, as well as he wants to identify all former or current clients of whom you have performed services similar to those provided to or on behalf of the Wayfarer defendants. And she wants that all the way from like, I think 2020 or something. Yeah, May 1st of 2020 to now. Like absolutely nuts. He's saying that based on the judge's order that they were supposed to narrow the interrogatory accordingly, but instead has not done that. They're seeking more information without any showing of relevance or proportionality. Then it says that even in Lively's letter in motion that they actually identified the interrogatories wrong. So the correct interrogatories are here. Lively's argument concerning interrogatory 14 is an expression of frustration that she does not like the answer she received. Indeed, Lively claims entitlement to probe the Wallace defendants' representations in response to interrogatory 14, in which the Wallace defendants answered under oath and verified that only one employee, associate, or subcontractor performing services for the Wallace defendants from July 1st, 2024 to December 20th, relating to the digital social monitoring project beginning August 9th of 2024. And its 2 stars, Lively and Baldoni, is Jed Wallace. But Lively's unhappiness with the answer and allegations of credibility concerns do not warrant the relief she seeks. To the extent Lively has questions regarding the Wallace defendants' credibility, those questions are best explored during a deposition, not through expedient motion practices. It's crazy that they did cancel his deposition. I read through the email chain that they provided, and I guess Lively's counsel said that they canceled it because they were going to get their stuff back from Tag, but it wasn't on time, so that's why they canceled his deposition. They could have got all of these answers through deposition, so it's kind of strange, but I don't know. But again, Lively could not have explored the credibility concerns she now claims at length during the previously scheduled deposition that she unilaterally canceled. By canceling the scheduled deposition, Lively passed on the best means to probe any purported inconsistencies in the Wallace defendants' discovery responses though none exist. Lively now asked the court to resolve that credibility determination on her behalf. The court should decline that request. Then they go into all of the stuff with Signal. And he's saying, I gave you everything I have. As you know, Signal automatically deletes text. I have mine on auto delete. There's nothing I can do about that. What you're asking for doesn't exist. I don't have it. And he says Lively is unhappy with the truthful response, now demands an impossibility that this court compel the productions of non-existent documents and communications. They've acknowledged that Signal automatically deletes messages, and he's saying he has that setting on because of the business and the type of work and communications that he does. So you keep asking and keep asking and keep asking for all the Signal communications, but he does not have it. Lively then suggests the Wallace defendants should have foreseen litigation as of September 16th. That's my birthday. As of September 16th, 2024. The record and Lively's case law demonstrates otherwise. First, the Wallace defendants has no objective reason to anticipate litigation until December 20th, when Lively served its CRD complaint on the Wallace defendants and subsequently leaked it to the New York Times. Why would he known about litigation as of September? That's crazy, just because they hired him. That's so nuts. Then he says the Wallace defendants' Signal messages were automatically deleted before receiving any notice of Lively's claims as part of the regular business practice in place. Which makes sense. I mean, you use Signal for a reason, right? Lively fails to provide any evidence suggesting that the Wallace defendants are not being honest about the auto-deletion policies applying to any potentially relevant Signal chance. Right, because then they're trying to say that, like, oh, if you use this case, I mean, he did it on purpose. He should have known. It's like, he didn't know that you're going to drag him into this. It's insane. At bottom, Lively cannot point to any authority where the duty to preserve documents arose 3 months prior to the service of a complaint based on a conversation with now co-defendants. Other stuff that they're asking for, he's saying, is attorney-client privilege, girl, and work product doctrine. And I have a privilege log, and my attorney does, of all of our conversations after December 20th, but I don't need to get that to you because I engaged with my counsel and we communicated about the strategy going forward in this litigation. You don't get your hands on that, okay? Lively is simply not entitled to the discovery that it requests. When a party asserts work product protection, the onus is on the requesting party to demonstrate that the documents are relevant and non-privileged. Lively makes no attempt to demonstrate the latter, relying solely on this court's statements about relevance in other contexts. Again, Lively's case law is readily distinguishable. This court should instead limit discovery to the time frame that is relevant. Exactly. Like her demand to extend the discovery time frame to the present, Lively demand for a privilege log of all documents withheld after December 2024, extending to the present, should be rejected. Judges in this district and beyond understand that producing a privilege log containing documents post-dating the commencement of litigation is an arduous process that yields limited relevant information. Then it says, while the Wallace defendants do not admit at this stage that responsive documents exist as to requests for products 10 and 11 as modified, they had no opportunity to confer with Lively regarding these modifications. Lively paints a picture that the Wallace defendants simply declined to respond to counsel's suggestion, but Lively omits that she provided the Wallace defendants counsel with this suggestion within hours of filing her motion. So who's doing it for PR now? Who's abusing the courts now? Who's not following the rules now? You gave them hours before filing your motion, meaning the motion was probably already written. The court should decline to address the dispute until the parties meet and confer as to requests for production 10 and 11. And then he does put little excerpts of her deposition in which she really can't name any articles that Wallace worked on or that he was a part of. And I don't know if she would be able to because they still don't know how this smear campaign happened. They can't even prove nothing yet. Nothing. And then she also said that, yes, some of the statements that were made, I guess particularly with Steve Soritz, that she was scared for her life. Yeah. I don't know when she had the time to be scared for her life, when she was, traveling around the world and going to Wrexham games and doing, red carpets and going to the SNL and doing all of this stuff. But yeah, her actions don't align with her words or her feelings, apparently. But yeah, that's what she says. Yeah, she was scared for her life, even though we are still here today for garden variety emotional stress. Yeah. But anyway, that's it today. It's going to be a good day. It's going to be a good day. It is Wednesday, midweek. Something's happening with me in 1 hour time at 4 p.m. I will be on with Leanne Newton live on her YouTube. Go check that video out if you'd like. I'm sure she'll post it a little bit later than the live. Also, the members section is open. The first videos will be posted tomorrow. So excited for that. It's only $2.99 Canadian. So I don't know how much that is American, but that's there. I just got an audition while I was filming this. It just popped up on my phone, so I'm going to go work on that. Lots of good stuff coming. I'm feeling good. I hope you're feeling good. This whole thing is just getting guys, when I say we're missing the plot, I don't understand, what's more important? What are we going for at this point? It's just absolutely, oh my gosh, it's just getting a little bit crazy. I think now more than ever, you can sense the desperation and just the sheer grasping at straws from Blake Lively's counsel. Tomorrow, Perez is in court. We'll see what happens there. I'm also following the Popcorn Planet motion, so I'll let you know if anything changes there. And yeah, I hope you're having a great day. Yeah, I don't really know what else to say except I'll wrap this up with I love you so much. I hope you're able to do something peaceful for yourself tonight, even if it's just 5 minutes, just to return back to home, return back to yourself. Sometimes that's all it takes is just 2 to 5 minutes alone to just breathe and be present and realign. And I hope that you're able to do that today and find just little moments of joy and real magic in the universe, because if you look for it out there, it will definitely show up for you, you know. But yeah, that's it. I'll see you all on Friday. I'll see you on Leanne's YouTube, and yeah, drop all your comments because I'll go through them and I'll read some of them on Friday when we're together. Thank you so much. Have the best day. I love you. Bye.